anyone who wants to become a pledge.
What fresh hell is this?
A deep and unique insight into agribusiness, services, ICT, and innovation, industrialization, and so much more. Entrepreneurs Hub, growing your small, medium, and large business entity. With yours truly, Sandra Kahunde.
You got us on your wallet. Bobby, again! What's the drama?
Elderly and persons with disabilities, it's time to choose our leaders. Let's show up and participate in the Special Interest Group elections. Starting June through August this year. Your vote, your voice. My vote, my voice. This message is brought to you by the Uganda Electoral Commission.
Hi, my name is Doreen Tuhidire, coming to you from Be Money Wiser, and we're going to be bringing to you the hashtag 100 Ways to Be Money Wiser by Mrs. T. Tilda Nabandra. We're going to be running this hashtag 100 Ways to Be Money Wiser on U24 television. Don't miss out.
U24.
You got us on your wallet.
Elderly and persons with disabilities, it's time to choose our leaders. Let's show up and participate in the Special Interest Group elections. Starting June through August this year. Your vote, your voice. My vote, my voice. This message is brought to you by the Uganda Electoral Commission.
Youth of Purpose.
Hello, my name is Erica Murunji and welcome to Be Inspired by Erica. So today I want to talk about in class so that you can be able to learn whatever they are teaching so that you can not forget and pass your examinations. Number 4, always complete your homework so that you don't be in panic and you can use it for revision when you're about to do an examination. Number 5, respect your teachers and peers. If you respect your teachers, they can help you with some numbers that you don't understand, and your friends can also explain to you if you don't know a concept. Stay organized so that you can make your teachers happy. Learning discipline for a better tomorrow, because the future is ours and the future is for those who are disciplined and organized. Thank you. Hello, my name is Erica Murunji and welcome to Be Inspired by Erica. Hope you're fine and happy to be alive. So today I want to talk about preparation for school. Welcome to a new chapter of learning. As you prepare for school, remember that this is more than just a new term. It's a fresh start to unlock.
Hello everyone, my name is Erica Murunji and welcome back to Be Inspired by Erica. I hope you're fine. I hope your family members are fine too. So today we're gonna talk about being kind to everyone. Please friends, be kind to everyone. Life can be hard and lonely, And if you're able to spread some goodness and positivity, do it without hesitation. Make people's lives better and make everything a little bit brighter. Surely, that's a good thing to do if the Lord has given you the capacity to do it. So let's stop trying to be hard to others, because we don't know who will lift us up tomorrow. Some people are going through a lot, so the least we can do for them is be kind to them. Do to others what you wish them to do to you. Life is like a circle, so please be mindful. What goes around comes around. Thank you for listening to me. Have a blessed week ahead, and please subscribe to my YouTube channel. Follow me on Instagram and Facebook. They all come in the names of Erica Murunji. God bless you. Much love.
Elderly and persons with disabilities, it's time to choose our leaders. Let's show up and participate in the special interest group elections. Starting June through August this year. Your vote, your voice. My vote, my voice. This message is brought to you by the Uganda Electoral Commission.
Good evening. Welcome our viewers. This is a Tuesday and this is a Checkpoint. Thank you for watching U24 Television, the National Youth Development. Tonight on the Checkpoint, we are discussing tribunals, bail applications, and judicial power. A case study of the NRM election tribunals and the Besigye ruling in his bail applications. We shall also be doing some tax, and I have an able panel this evening, but I'm sitting in for Ivan Tumukunde, and my name is John Vianney Ayawale. Right from my far left, I have Jonathan Areba, and he's a lawyer from the Law Development Center. Jonathan, you're welcome on the Checkpoint. Please say hi to our viewers.
Thank you, John, and it's a pleasure to be here. Good evening, our viewers.
Next, I have Sarah Anjoa. I hope that's a proper pronunciation of the name. You'll correct me if I'm You're welcome, Sarah. Please say hi to our viewers.
All right. Hello, everyone. My name is Anjoa Sarah, and I am thrilled to be on this show today.
Right next to me, I have Charles Mayanja Goodluck. He's a lawyer from the Law Development Center. Charles, you're welcome.
Thank you, John. I'm glad to be here.
Thank you very much, my dear panelists. I want us to start right from where we should. Tribunals, bail applications, and judicial power. I want to start with Jonathan. What is a tribunal? And where do we get tribunals from?
First of all, a tribunal is a semblance of a court. For example, the mainstream courts. However, tribunals are not courts. They are an other system of dispute resolution, usually created by statute. The constitution allows the parliament to make tribunals, and in Uganda we have a number of tribunals like the Tax Appeals Tribunal, the Insurance Tribunal, among others. So really they are mechanisms of dispute resolution that are outside the mainstream court system. But I think also it is important that for this specific talk show I state that we will discuss largely the NRM Tribunal, which is a creature of presidential directive as by President Museveni, the chairman of the NRM party. So it is basically created for the sole purpose of resolving any disputes that might be as a result of the recently concluded NRM election primaries.
Thank you very much. Just hold it there, and then I want to go to Sarah to tell us about judicial power.
Okay.
What is judicial power?
All right. So thank you very much. So from the context of speaking as a lawyer now, the Constitution of Uganda, ranging from Article 126, introduces that concept of what judicial power is. And when we are speaking on judicial power, we are looking at the people who are interpreters and implementers of the law, and these are majorly judicial officers. Now, their role, firstly, is to serve the people through interpreting the laws, and they ought to do this within a certain confine. And these confines include things like impartiality, fairness, independence, and things of that category. And I think for this conversation today, our conversation will majorly be around what is the standard of what the judicial power should be, how should it be exercised, and for who, and is it upholding the constitutional standard that covers the people and the welfare of the people? Yeah, so I think that is an insight on what judicial power is. So when you're speaking about judicial power, the people who are comprised therein, we have the judges in courts, we have the magistrates, but then also when we speak of tribunals, since they're also an arm of justice delivery and interpretation of laws, we could apply some of those standards to tribunals. Things like
there is a saying that judicial power is derived from the people.
Oh, yes.
How true is that, and how is that possible?
Oh, well.
Because these people must fear courts. How is it that they are the people who give judicial power?
Oh, yes. And that's quite right. There is a true north, and the true north is that judicial power is derived for the people, because the heart of law is when we look at the different schools of thought. Yes, we look at that concept of a social contract where people come together and they're like, we would love this person to lead us as a community in a social contract. And that's the community we live in. So we're saying we want to have these guidelines that will guide our community, and we would love that judiciary to promote this. Now, that is where we say they are exercising it on behalf of the people. We are giving them that mandate. However, it's funny how things change here, there, and they become the intimidators, and I think it's a conversation we shall be having.
Thank you very much. Over to you, Charles.
Yes.
Bail, the concept of bail. I think people hear bail, bail, bail. What is that bail?
Thank you, John, and the viewers who are listening and viewing in there. Bail simply is a temporary release of an accused person from custody under conditions set by court. Basically, what informs bail basically is the principle of presumption of innocence. Under our law, specifically Article 28(3)(a), it provides that a person is presumed innocent until court of a competent jurisdiction pronounce against his fate. So, bearing that in mind, then court can grant bail or as a temporary release of a person under the terms set by it. Much as the Constitution and other laws like the Magistrate Courts Act provides for bail, there is a misconception out there that you have a right to bail. You actually don't have a right to bail, but you have a right to apply for bail. So those are the discussions that we shall be having in the light of the recent ruling in the bail application of Uganda versus Besigye and Abedi Rutali.
Thank you very much. I will be getting there, and the distinction between a right to bail and the right to application for bail. You'll be telling us more. But I want to go to Jonathan Areba, and I want to specifically go back to the issue of judicial power. I mean, why is that very important?
Judicial power is important, John, because we run a democracy in Uganda. So we have three arms of government, that executive, legislature, and judiciary. And judicial power is the last hammer. It's the last sword that judicial officers wield on behalf of the citizens. Like you're asking whether that power is derived from the people. So in an ideal democracy, judicial power is the last sword that judges wave on behalf of the citizens. So it is important that that power is heard and is exercised judiciously. So for context, if we have unchecked judicial power, it could be problematic. But if we also do not have, if we have stringent limitations on what is judicial power, we also have problems.
Thank you very much. Sarah, you want to add on that? Judicial power, its importance, because he brings in a very good, angle that it acts as a check, I mean, would it be as dangerous if we said we don't have now the judiciary, and some people may say, I mean, even why do we need it in this country? How dangerous would that be?
Well, firstly, it would be very dangerous, because when we look at the human setting and how our communities are governed, there is need to have regulations. Yes, there is need to have regulations, because if there are no regulations, systems fail. If there are no regulations, rights are violated, and perhaps shared goals are not achieved, because in community we have shared goals. These could be goals towards development, goals towards certain forms of sustainability, growth, in that category. So now, due to these needs in community, there is a need for law. And when you look at the different schools of thought that speak into what are laws, and at the end goal of a law is welfare. That there is well-being in society, that a society is thriving and people are safe. Yes. Now, when there are laws without enforcement mechanisms, then the laws become silent. They become perhaps useless, because laws they have to be enforced. Now, judicial power is that enforcing mechanism, because firstly, it interprets those laws, but then also enforces them through perhaps decrees and orders and, sanctions, penalties and things of that sort, yes? So we understand that we need laws to regulate society, and judicial power is that arm. So without judicial power, there is a void, and that void causes challenges.
Thank you very much. Yes. I want to come to Charles, especially you've talked about competing interests. The state has interests, individuals have interests, and those competing interests may sometimes go the clash if they are not well regulated. I want to specifically take an example of the recent complaints. The traders have come back complaining about IFRIS, yeah? And I want to understand very well. First of all, we need to know what this IFRIS is. And then Charles will be later on telling us the remedies, because a taxman is also very well empowered with so much power, and judicial power is also connected with enforcing tax laws and what have you. So what should the traders know about IFRIS?
Thank you, John. I'm glad you asked that question. IFRIS basically is what we call electronic fiscal receipting and invoicing solution. Different from what the public out there knows, that IFRIS is tax. IFRIS is not a form of tax. There is no tax in Uganda called IFRIS. That should be on record. IFRIS is a system, is an electronic system, it's a computer system that you are able to improve and enforce compliance by the taxpayers. So given that we have that system and there is misinformation, then there is a need to, like you said, for judicial power to address the complaints, to address the complaints from the public. However, in tax matters, judicial power is exercised differently, in a way that it depends on which kind of dispute it is. The Tax Procedure Code Act defines what a tax decision is. So if something amounts to a tax decision, then judicial power is exercised from what my land friend said, tribunals. So there are tribunals that enforce decisions that amounts to tax decisions. So that's how judicial power in taxation is exercised. However, if the dispute is not what amounts to what is called a tax decision, then it can go into the mainstream judiciary.
So like in this case where traders are unhappy with IFRIS, what's their recourse? Can they go to the tribunal? Where
you are not, because you need to first of all check the tax procedure code. Is the decision to bring a system to enforce compliance, a tax decision in the meaning of a tax decision under the Tax Procedure Code Act. my answer would be no. So for that, it means that to address this, you need to petition the mainstream. Now, when petition the mainstream, then you have to engage. And basically, since now the introduction of IFRIS has been codified, it has been put under our laws, because before it was largely governed by regulations made under the Tax Procedure Code Act. But recently, the amendments have now included it in the under Section 92 of the Tax Procedure Code Act. Therefore, if you are challenging it, you either claim it is unconstitutional, and then you go to the Constitutional Court to find out whether that provision in the Tax Procedure Code Act is actually constitutional or not.
So the traders,
but that does not amount to a tax decision.
Tax decision. So the traders at this point, it seems you may need to really find out other solutions, including contacting lawyers as intelligent as we have here, to perhaps file a constitutional challenge, because as of now, it appears you're fighting an existing law. It is now law. Perhaps our MPs should have represented the traders much better in the process of amending.
Definitely.
But I want to go to Jonathan, and we take an example of the NRM Elections Tribunal. The tribunal has recently released some decisions. And you gave us a very good background to the extent that you have tribunals, some are a creature of statute, others are a creature of some regulations, and you said this one specifically is made under the directive of the president of the country, who is also a chairperson of the National Resistance Movement. How binding are these decisions?
That's a tricky question, John. You see, I think we need to differentiate between the NRM and Uganda. Because of, I think, the size and the magnitude of the NRM primary elections, we tend to think that that is a national election. It's not a national election. It is actually a political party primary election. Now, with that in mind, you would have to consider the fact that when you subject yourself to an election process under the NRM, you have subjected yourself to its system, to its electoral regulations, but also to its dispute resolution mechanism. And that's where the tribunal comes in. Of course, I've watched John Musime, who is the chairman of that tribunal, say that the decisions of the tribunal are final and they cannot be appealed. And I agree with him to the extent that in the NRM mechanism, you cannot appeal that decision. And an appeal is a creature of statute, John. So if there is no creation of an appeal, then a person who is dissatisfied by the decision of the tribunal has no recourse. I am yet, and we are yet to see someone who challenges the decision of the tribunal, maybe in the mainstream courts, and I would be intrigued to understand how they do it. Would they file a fresh suit? How would they proceed? But also when you consider the timeline, it seems impossible that you would appeal the decision of the tribunal and get a decision before the 2026 election. So how the tribunal is created and how it operates, but also the circumstances of the case, suggest that the decision of the NRM tribunal is actually a final decision. And they are working around the clock. I think there are about 30 members of the tribunal. There are about 8 panels of the tribunal, and to decide over 400-something petitions in a period of 30 days. So imagine if each tribunal has about 7 days to determine a petition. You can imagine the magnitude of petitions and how long it will take. And I'm sure that timeline will not be enough. They will have to exceed that timeline.
Sarah, I want you to bring in right there, especially on that point of Jonathan, where he says that he agrees with the chairperson of the tribunal that those decisions are final. And once you've subjected yourself to that process, accept what has come out and move on. Do you agree
First of all, I strongly disagree, and I believe it's from the heart of disagreeing that we now bring disruptions into changing what the system is. So picking up from the point, there's a principle called sui generis that talks about the strength of the Constitution and how it is the heart of each and every law that is and should be in Uganda. And that does, and it's not exclusive of the NRM, the election regulations of NRM 2025, or how the proceedings in the tribunals are done, because all these things are guided by the Constitution. And you see, in the process of justice delivery, Article 28 of the Constitution is very paramount, and it's at the heart of what the process should be like. So are they doing this just to fulfill due process that, okay, people had complaints, there was violence, let them come and give their complaints, and just for formality? Because the way it has been done, the rushy manner, you know, the unheard pleas, shows that this has just been a mode of formality to show that, yes, perhaps we're impartial, perhaps we care, and we want to see what you could do. But what is the substance of these processes? Is it yielding forth in-depth justice? And
we have some instances where the results have been overturned. In Terego, I think it is Terego South, they overturned the election, the results, and declared a different candidate as a winner. A different candidate. Now,
I saw in the newspapers we had about 40 overturned. But then how many people applied? We had about 300 people who applied. And when you look when you have an in-depth analysis of some of the challenges they had, you even realize that the election regulations for the NRM of 2025 is very unself-contained. It does not cover for all the challenges these people faced. You know, I perused through it very in-depthly, and there are things it does not even cover for. There are some electoral malpractices, things like violence.
Do you think the mainstream courts, because we are speaking about judicial power, do they have anything to learn from this tribunal handling these complaints in the shortest time possible?
First of all,
because as we are heading to 2026, many complaints are going to come through, you know, from MPs and from perhaps the presidential elections. Is there anything we can pick from this tribunal as we head to 2026?
I think what they can pick, first of all, are the failures of this tribunal, you know, because the practice that they have been having is just a blanket view, just having something just to be done. You know, they're not getting in depth to see how much justice we can deliver. But then also the numbers they have been having in a day, they're handling over 50 cases. How effective is that, you know? So we also have to bring in the question of effectiveness when it's, because election, even the standard of deciding election matters is a bit higher than the other standard in other civil cases because of the technicalities that come with election petitions. So it's not a very obvious thing, but then also keenly the gaps that are in the NRM election guidelines. So many gaps that have to be filled. And you see, when there are gaps in laws, it's a sign that they are being intentional on oppressing some rights of other people, because some of these gaps are quite obvious. There should be...
Thank you very much. Charles, I want you to come in here and assist us. Because judicial power, I think they have to be accountable to the people. That's why we're here, we're discussing, and people have always commented here and there. And the reason we have taxation and all of that is because government wants to raise the revenue. Definitely. Yeah. How do we balance the needs for government to raise the revenue and also holding accountable the same individuals that we really, you know, finance to do this, including judicial officers, tribunal, whatever? How do we connect the two? Perhaps the reason why people are fighting not to pay tax through the system called IFRIS could also be solved. What's the link between taxation and accountability, especially in the field of judicial power?
Thank you, John. Yeah, it is a tricky question, but it's unfortunate that there is a principle of non-quid pro quo in taxation, in that when you pay when you pay your taxes, you are not required to ask government what they have done with the taxes, because when you pay taxes and maybe you're in Kampala, the government is free to use the money from Kampala taxes to any place in Uganda. So that's why there is that principle that you must not. Now, the solution for mismanagement of taxes, I think, should be dealt with politically, because now the people we elect, the people that we put in parliament to form the legislative arm of government, and the people that become the ministers, and they influence a lot of policies. So I think the solution for accountability really is, I understand that judiciary has a role to play, but before the judiciary come in, you as the public, as a voter, what have you done to ensure that the people you're putting in offices are those with the integrity enough to protect public funds? So basically, if we wait for the judiciary to come in and we pursue the corrupt officials in tax, in maybe URA, in government departments, in my opinion, it will be too late. So the earliest opportunity, in my view, is that you, the person, now that we actually into the election period, it's at this time that we are supposed to sieve through, are the people we are entrusting with public authority, are they the right people to be trusted with that authority, so that we avoid such issues. Otherwise, yes, the judiciary is there. We are supposed to adjudicate tax disputes. We are supposed to adjudicate, to prosecute corrupt individuals, those who embezzle government funds and everything. But then that is too late. And I think as the public, you have a duty to also ask for accountability. Yes.
Thank you very much. Jonathan, I saw you. I don't know that we are agreeing or disagreeing, but I want you to come in. The link between taxation and judicial accountability.
Yeah. Whether I agree with
Charles.
I do not agree with Charles to the extent that when people pay taxes, those taxes should not be accounted for. It would defeat the entire social contract.
I think the point he made was that they can be accounted for, but not demanding that since I've paid the tax, you must construct this road.
That is what I meant.
Yeah, maybe perhaps if he puts it that way. But I do think that judicial officers and judicial accountability should not be looked at only under the ambits of tax. We should look at it, and I know we will get to that discussion when we are discussing bail, but on what kind of decisions are judicial officers giving us, even those that touch things like tax. Because, like I said, when all the other arms of government, when Parliament has legislated the use of IFRIS, and executive has brought this new system, and maybe the traders are struggling with raising taxes legislated by Parliament, of course, at the end of the day, who does the normal person go to make his case? And that is a judicial officer. Now, if the judicial officer is not accountable, you and me, John, will remain struggling. And that is the importance of judicial accountability, one of the importances of judicial accountability as I understand it. So I think that it is very important that we have accountable judicial officers on all the ambits of matters that go before them.
Thank you very much. I'm going to come to Sarah on that, especially bring in the types of decisions that we get. What kind, I mean, I'm going to come to Sarah on that, especially with the focus on the recent decision in the Besigye bail ruling. But thank you for watching, dear viewers. And we are streaming live on social media. We are live on YouTube, and I will be taking your feedback that is coming through on our social media platform. So please, you can go on our YouTube channel and then you comment. I'll be reading your comments. I see some feedback is coming through. But before that, Sarah, we've got a decision, I think it was on Friday, where Besigye once again was denied bail. How do you make of that?
Now, when we look at some of the reasons as to why he was denied bail, he spent, the law provides that there's a certain period of time that when you spend in custody, then you deserve mandatory bail, you know, and that's approximately 180 days. Now, the truth is, Kano Besigye has spent even more than that amount of time. But then they did not count the period of time that he spent when he was in the military, is it courts? Yes, when he was being held in custody in the military areas. So the fact that they didn't do that, yet there is a Supreme Court decision that provides that we should count each and every time period someone has spent wholesomely in any form of detention, not particularly our national prisons, yes? And there we see a very big loophole, and therein comes political conversations on the impartiality around such a decision. And we start throwing out names like, okay, I would not, we start to wonder, I would not want to get overly political, because this clearly is a political saying, the dear late Justice, as he then was, Kanyehamba, did say that where there are guns, the law is silent, yes? And of course, the law, there is a standard with the law on conversations around bail, but now in this situation, we have guns as well. That is why even us in our speech, we are very speaky, you know? But then truthfully, we would now wonder, what's the situation concerning cadre judges? What type of decisions are they making?
But is there anything like cadre judges, or it is a social construct?
Oh, well, everything begins from being a social construct before it becomes a standard view. It comes from a social, and you know, even that social constructs come from what is reality, what we can see. Yes, because when we balance the law and what is happening clearly, there is a very big divide. There is a very big divide that destroys the standard on what.
The argument has been that once there is a decision that agrees with you, you say this is not a cadre judge. Once the decision is against you, then you say this is a cadre judge.
But then what if the decision is against the standard? Because there is a standard, which is the Constitution, and that brings out the conversation around what bail is, what bail should be, and also the bail guidelines have all those provisions. So clearly there is a standard, it's not being followed, and it's bluntly not being followed. And that then we would suggest political thoughts around that.
I want Charles to limit his submission on the standard for grant of, and I want us to understand the two types of bail, mandatory bail, and then this normal bail, I can call it bail. Just tell me those standards. What are those standards? She says they are standards. What are those standards? What is mandatory bail and what is the usual bail?
Basically, thank you, John. The bail, the normal bail, as you termed it, or I could call it discretionary, which is given at the discretion of the judicial officer, is actually the one provided for where like you can apply for bail at any point, and so long as you meet the conditions set out by court, you have sureties and any other conditions that the court may set. But when it comes to mandatory bail here, the judicial officer has no discretion. He has to give it to you. Now the question is where the terms that mandates a mandatory bail, that warrants a mandatory bail in the recent ruling, were they fulfilled and bail denied? In my opinion, I think they were not. However, like I agree with my line friend that there is a lacuna, there is a gap in the law that when you peruse through the law books we do have, it was so hard for the judicial officer to account for the time that was spent in the military court martial, because the law under which the court proceeded was that one, you must have spent 180 days on remand where you have been remanded by a magistrate court. That was clear and in black and white. Two, you must have not been committed to the High Court. That was also clear. So basically you had two, the standard composed of two grounds. One, 180 days on remand occasioned by a magistrate court. Two, you have not been committed to High Court. And of course, where the offense is a capital offense trial by the High Court. Now, we have from the school, different schools of thoughts. We have those judges who are positivists, who will take the law as it is. So such a judge, reading that provision, definitely would come up with the very finding that the Land Justice Baguma came up with, because the positivist, that's what the law is, and that's what it should be. However, we also have legalistic judges, or what we call legal realism. Now, yes, the law provides for this, but what is the reality? The reality is the guy has been in custody for over 200 days or something. Yes, he has been committed. The DPP would argue that the mandatory bail application has been overtaken by events since the accused person was committed in the High Court. So for a realistic judge, that would be enough to maybe grant the bail. But for a positivist judge, I would agree that I don't find any loopholes in the way the judgment was delivered.
Jonathan, Charles makes a point that the law provides that you must have been on remand by a magistrate court. Is that the position? And also, he also submits that accounting, on the issue of accounting for the time which the person had spent on remand on account of a military court-martial, is that a standard? Because when you look at that judgment, there were affidavits. Yeah, there were affidavits which were sworn. And in criminal applications, I think there is a law which says evidence may be by affidavits. The judge says there's no evidence to show that the person has been on remand since 20th November. Was there no evidence, or there was evidence?
The judge said there was no evidence to show that the man was on remand since November, which, like he labored to explain, could be interpreted in different ways. So I will simply give you my take. While I hold my political cards closer to my chest, I commend Dr. Besigye for the contribution he has had, knowingly or unknowingly, to the jurisprudence in this nation, especially on the bail application. You cannot forget the previous bail application that Besigye had on the right to apply for bail and the right to be granted bail. And
in fact, I think that principle we are quoting, that there is a right to apply for bail and right not to apply, is derived from one of his cases.
Yes, Besigye is locus. Now, we must understand that how the Besigye comes before the magistrate's court to be remanded follows a decision of the Supreme Court, which was declaring the court-martial as, in quote and unquote, in the words of one of the judges, as a disciplinary committee, but among others. So, and we were happy about that decision, and the net effect of that decision was that whoever was being detained by the court-martial should cease to be detained. Now, the theoretical interpretation of that decision is at that moment Besigye was a free man. However, the practical interpretation of that decision, and those are the nuances that Charles and my learned friend here were taking you through, are that there is the realities that we go through, but there is what is lawful and theoretical. So I don't want to disagree with a judge who says that before the person was presented before the magistrate's court to be remanded on the capital offense, which is of treason, by the way, which on paper again appears to be a very heinous offense, that you would struggle to grant bail, and the judicial official will pull each rope available to them not to grant that bail application. So I don't disagree so much with that judicial officer who says that you can only compute the timelines as and when the person was remanded. But I also hear people who make the argument that Besigye was in the knowledge of everyone. It is so conspicuous that he was arrested by the military of this nation, detained in a prison. Matters were heard at that time in a lawful system before the Supreme Court's decision. So it should be notorious to the judicial officer that he was actually detained. And I would make a case, I don't know if the lawyers made the case in their affidavits and submissions, for the rationale of the 180 mandatory days. And for me, that rationale would be that if someone is subjected to a system detained for all these days and he has not been committed, the reasoning of giving mandatory bail is that you cannot, it comes back to the presumption of innocence. That Chiza Besigye is a person presumed innocent until a court of law proves him guilty. So why would he be subjected to a lot of time in prison, yet no action is being taken by courts of law? And when you think from that angle, maybe we could reach a position that since it is so conspicuous that he was arrested by a national army, detained in a national court-martial that was operational at that time, the days should be computed. We are yet, of course, to see what courts of law decide about that. Maybe he will give us yet another precedent.
Okay, thank you. So Sarah, what's the danger, the decisions which you're talking about, what's the danger if we have decisions that create division in interpretation? Because it appears that the interpretation is as much as there are lawyers of this very decision. Some agree, some disagree. What's the danger of having a standard that's not clear to everyone, especially in matters that affect fundamental rights? Because presumption of innocence is a fundamental right, non-derogable. So how do we ensure the standards, and what are the dangers of having standards which are not clear to everyone? Because today, now we are not sure when do we start counting time of remand. When you're remanded by a certain tribunal, or a disciplinary, whatever he called it, disciplinary committee, are you on remand? Should you wait to be in a magistrate court for you to say you're on remand? What's the danger?
Now, firstly, even before I get to that danger, it's very important to note that there is what we call hierarchy of the court system. And the hierarchy of the court systems now give us the understanding on which decisions hold more power. Now, if there is a decision that is coming from the highest court, which is the Supreme Court, then we would hold that decision as standard. And this is a decision we believe would come with utmost discretion and in-depth analysis, interpretation, and application of all judicial principles of impartiality, fairness, and natural justice, yes? So that usually is the standard. Now, the intention of having these standards is to ensure that we reach the intended goal of having these laws and regulations, which is achieving justice, which is protecting the right of people. Now, once we have a disorganization or an uncertainty on what the exact standing is, when we have lost the standard, then at the end of the day, it's very obvious that we are not going to have justice prevailing. We're not going to have rights protected, meaning as a country, the state of our rule of law crashes. When the state of our rule of law crashes, of course, rights are not being respected. And this ends up affecting each and every area of our being as a country, including our economy, because laws are what regulate all these systems. That's why we have to look at these standards very, very keenly. And it's very unfortunate that the standards around perhaps bail have been fluctuating over time. Today we have a good standard, like the Kano Besigye. He did us a very good precedent right back in 2006 when we had the very famous case around bail. And that case did provide very good standards around bail, especially upholding the importance of why we have bail. Firstly, fronting presumption of innocence, but then also why is someone being given bail? When you're given bail, you're given time to prepare, to be able to front your case better. So bail also has some logical, practical, but also other humane reasons why people are given bail.
Thank you very much.
Yes.
Sarah, I have feedback coming in from YouTube and our social media channels. Martin Musajakawa says, thank you so much, Mr. Mayanja, for the great information. Charles, you're doing well. Then Chichoncho Agnes is saying, good evening, Mr. Charles. how can businesses operate within the law but avoid paying IFRIS tax? So you'll pick that. Perhaps I can give you time to answer that.
Thank you.
Is it possible to do that?
Thank you. Like I said at the introduction of this show, that IFRIS is not a tax. Just like you've had the question, there is a lot of misconception that IFRIS is tax. IFRIS is not a tax, but is a system of tax monitoring and correction and enforcing compliance. And it stems from the fact that we Ugandans, as a culture, I don't know how it came about, we are dishonest. I can frankly say that Ugandans, the biggest proportion of Ugandans are dishonest at this level. So the tax system was designed to be self-acting. Like, you assess your own taxes, you file your own self-assessment, you do everything in the open and tell you, hey, these are my income, these are my expenditure, this is how I spend, this is how I earn, honestly. But now that traders and business people cannot exercise the honesty required in self-assessment, then you are asleep and say, what can we do? Let us bring a system that will capture and monitor every transaction that a trader is doing, so that at the end of the day, we can tell that so and so has sold goods worth this money in this year, has sold this and this in this month, has spent this and this, and therefore the system computes the tax and said, no, so and so's income tax, for instance, is this and this, so and so output VAT is this, and so on. So it all stems from our failure to voluntarily comply with the tax system set in place.
Okay, thank you very much. So it means you cannot avoid paying IFRIS because itself is not a tax. It is, from the submission, means of collecting the tax. Okay, thank you very much. Chichoncho Agnes also has a question. Says, Sarah, can a common person represent herself up to the highest level of courts?
So self-representation in law is very possible. It is possible. However, the law in its practice is a very complex arena. So there are some technicalities that are common, or a lay person may not be able to uphold, and that could even affect how they would receive their justice at the end of the day. So yes, it is possible, but then it is also very technical and challenging. But in case, of course, we do recognize that there are people who do not have ability to afford perhaps lawyers, advocates to represent them in court. That's where legal aid comes in, and there are very many legal aid arenas in the country. We have the legal aid clinics of LDC, we have LapsNet, and we have FIDA Uganda, among others. So I believe these would cover people in that regard.
Thank you very much. So if you're there and you need legal representation, you could approach any legal service provider, especially those who are able to give legal aid. Even Uganda Law Society, once you approach them, they are always able to link you to a lawyer who could assist you, especially if you want to go to the highest levels of court, like Shiroi Terasats, the procedures, and the complex nature of the law may be difficult for a common person to move around. Then Martin Musajakawa says, I think non-quid pro quo is unfair to our bureaucracy. Mr. Mayanja, how are we supposed to know the accountability of our money, especially us who pay a lot of it from salary, pay as you earn, yeah? That's a concern. And then he continues that, seriously, you pay tax worth gross of a U7 worker. And for sure, someone tells you the non-quid pro quo principle. Don't we need accountability? Then Mubanjizi says, thank you for the great work. He thanks the panel that this is informative and is very educational, especially to me and my fellow learning lawyers. Thank you very much, Mubanjizi, for following. We are here every Tuesday, and you could spread the news, because every Tuesday we are here on the Checkpoint, checking the law. So I think Jonathan talked about the principle of non-quid pro quo, and in his agreement was that you need to do some kind of accountability. Expound more on that, especially for Martin Musajakawa, especially also on understanding the pay as you earn, that he pays a lot of tax, the same as a U7, and I think this is a grade for people in public service and what have you, the amount they pay the workers.
So I think that tax is one of the greatest ways any government anywhere can make money. And the problem comes in, like our dear listener points out, where a lot of money is collected and it is not accounted for. And we have different modes of collecting this tax, from IFRIS that we have been discussing, from importation, from even employees, which now would pass off as pay as you earn. The question is, when you pay that tax, is it accounted for? Of course, we cannot subject a nation to say that since you have collected 10 billion from Kampala, show us how that 10 billion has invested in Kampala. And I think that's what my friend Martin was pointing out, that we might, yes, collect billions and billions here, but we need a dam in Karuma. So we would go and construct a dam in Karuma. But I think the net effect is that every Ugandan should feel in a nation that taxes are contributing to the development of infrastructure. We talk about roads, hospitals. You would be surprised, John, if you visited some health centers deep in the village and see what the situation is there. So I think that that's what prompts such emotional questions from viewers to ask you that are you for? And you know how much are you for pays in tax as pay as you earn. So telling me that I need not be given accountability would pass off as harsh. And that is why at the start I had disagreed with Martin, but I later understood how he had made his case. How then does the government become accountable on tax? I think it is a simple thing. When we pass the national budget, does it speak to things taxpayers are interested in? Or do we pass a national budget? Every time they read a national budget, people, and I myself inclusive, we are interested in how much has been allocated to state house, how much has been allocated to the military, how much has been allocated to the office of the president. And when you look at that, it does not necessarily reflect to an accountable government.
Okay, thank you very much, ladies and gentlemen. Our time is fast spent. I want to pick your last comments on this, and then we come to the conclusion of this. So I will start with Charles. Your final remarks.
Thank you. Our viewers who have been viewing and listening in on U24. It has been a good time here, and we wish that no one is found in a situation where they are denied bail in unexplainable circumstances.
I see. Thank you. Thank you very much, Charles. Everyone deserves a right to apply for bail, but if it is mandatory then?
If it's mandatory and you've satisfied all the conditions, we pray that you never get denied.
Okay, thank you very much. Over to you, Sarah.
Thank you very much, first of all, for hosting us here today. Now, mine is a food of thought, but especially for our taxman here and any tax authorities who could be watching this today. Now, we have noticed a lot of rebellion around paying of taxes, and my dear land colleague mentions that Ugandans are perhaps very dishonest. But if we look at the level with which people have rebelled against tax or raised so many concerns, it would make us raise an eyebrow as well on why is this happening? Are the tax policies unfair? And when you look at some of the principles of taxation, you know, taxes have to be fair. Why are people trying to evade these? So I think that's an area we have to look in-depthly into. I mean, I'm buying a car of 50 million and I'm paying a tax of 49 million. I think that's an area to look into. What are our tax policies like and how can we make them fair? Thank you very much. I am Anjawasa.
Thank you very much. Over to you, Jonathan.
Thank you, and John, and thank you for hosting us. I thank our dear listeners. Among all the other things we have discussed, I am also drawn closely to tax. And my parting shots, for me, is not to the necessarily to the local man who is making his money. Please comply with what Martin has said, pay your taxes. And me and you, we hope that these taxes are accounted for. But my parting shots really are to maybe the URA, the regulatory authority. Sometimes it is, I cannot fathom raising some levels of taxation to 5% to 30%. I watched in Ora recently, where glassware tax on glassware in this nation was raised from 5% to 30%. That 25% could be the profit someone is making, and you tax it. That would cripple businesses, and the butterfly effect would suggest that 6 years down the road, you don't have businesses to tax. So while we commend the EFRI system, as Martin has expounded, and very many other
I hope you're
things
referring
in
to
taxation.
Charles.
Yes, Charles. I'm sorry. While we commend the EFRI system, as Charles has pointed out, it is also important for the government to know that taxpayers will only pay tax. And I think it is a canon, a principle of taxation, that it should never be a burden. The taxpayer should never sit home and feel burdened to pay tax. It should come easy. But otherwise, I thank you for having us here, and I look forward to...
Thank you very much, Jonathan. This evening, I had Jonathan Arewa, who is a lawyer from the Law Development Center. I had Sarah Anzoa, a lawyer from the Law Development Center, and Charles Mayanja Goodluck, a lawyer from the Law Development Center. This is a Checkpoint. It comes to you every Tuesday, 9 p.m. to 10 p.m. on U24 television, the National Youth Development. My name is John Viana Yavare. We will see you next week. Coming up is U24 Cinema. Stay tuned.